Welcome to the Business SOS podcast. This is Rich Sierra, president of Florida Small Business Legal Center. Today, I'm doing the podcast from my office here in Boca Raton, Florida, due to some logistical challenges. For those watching me on YouTube, I was not able to do a podcast last week. I apologize for that. We're going to try to continue doing this on a weekly basis. Today, we're doing it from my office. So as I begin the show, if you have any legal questions you would like me to answer for you, send me an email at rich, R-I-C-H, at richsierra.com. And for those of you who are interested in learning more about my legal practice, you can go to my website at floridasmallbusinesslegalcenter.com. This is episode 61 of Business SOS. I'm very excited as we continue getting close to that. Episode 100, we'll do that one at a time, but we'll get there sooner or later. Today's topic is going to be what to do when things go wrong in your case. And I think that is important because there is a misconception that everything that we do is going to work out perfectly throughout the case. And I think if I have a criticism about my profession is perhaps some of these ads that we see on billboards and primarily deal with personal injury, that you hire us, we're going to get you $1 million. It's just not realistic. The reality is that litigation is a journey and it's a process. And in some cases can take, in a good day, can take about 12 months. That's a fast track here in Florida. A little bit general track is 18 months, and a complex track can take 24 months. So and throughout that process, there are going to be a lot of different motions and processes that, for the most part, unless you're an attorney practicing litigation, you're not going to understand. I want to tell you that in some cases, in fact, if you have a case that is going to take you about a year, very likely you're going to have some rulings that are not going to go your way. And I want to talk about some of those instances which that could happen so you don't panic, you expect it, and you manage expectations if you're in any type of litigation process. And again, it's primarily because of the unrealistic expectations that sometimes people have about, that everything is going to work out perfectly. And unfortunately, attorneys do not explain that to the clients and telling them, listen, sometimes we're just not going to get rulings our way, and they're panicked and surprised when the judge rules against you, an emotion or something to that effect. So generally speaking, the litigation process takes a number of steps. It starts with the initial complaint that somebody files a lawsuit and somebody gets sued. And then you begin to analyze the lawsuit. That's the initial pleadings that go in. And when somebody is getting sued, then the attorney will look at that lawsuit and see whether or not it's a possibility to file what is called a motion to dismiss. You begin to attack the structure of the lawsuit and whether it's technically correct. And that's the first thing we do. And when we file a lawsuit, that's most likely the first thing that the other side will do. Is there any defects in this lawsuit, whether it's by fact or law or statute or case law, that we can attack it and not even get to that first base? So that's the first thing we look for, and that's the first thing that we can expect. So say you're a plaintiff and you're suing someone, say for breach of contract, and they file a motion to dismiss, okay? And it could be for a number of grounds. It can be for failure to state a claim. It could be for statute limitations, although very seldom an attorney should count, how many years since the event took place to make sure you don't run into that error. There are a number of reasons why a complaint can be dismissed. It could be, not attaching an exhibit, something as simple as that. So we look at that and you get upset, they're filing a motion to dismiss. And we usually file a memorandum in opposition. We kind of tell the court, no, this should not be dismissed, and this is the reasons why. But say, for example, the court dismisses your complaint without prejudice. What does that mean? What it means is that, you have another chance to fix it. That's all it means. That, it is without prejudice, and they give you, say, 20 days to file what is called an amended pleading and fix that lawsuit. So that is the worst can happen when you get a motion to dismiss. And I file those motions and they're filed against me. And sometimes we might have missed something that maybe throughout the pleadings, we just didn't realize that it was just missed in the drafting process. It could be something as one paragraph. one allegation that we could have missed that would have gotten over that hump. So a lot of times the attorneys will meet and confer. In fact, in Florida, now it's a requirement that before a motion is filed, we have to meet and confer with the opposing side by telephone and discuss the merits of the motion, see we can resolve it without going to court. And we should do that to give the judges a break, not to have this decide things for us that we can perhaps fix ourselves. And many times what we do is that, okay, you know what, you might have a point here. Let's agree on an agreed order to dismiss without prejudice and give me 20 days to amend the lawsuit and a file amended complaint. That's the worst can happen. So if you are faced with a motion to dismiss, don't panic. It is standard practice for litigation, especially business litigation. We filed it, they get filed against us, and it's basically focusing on technical aspects of that lawsuit, but it's a defensive pleading. And in fact, the reason it has to be done that way is that if you do not file that motion or raise certain defenses at the very beginning, you waive those defenses. You cannot raise them again later on. So you do that to preserve defenses. That's just an example of a ruling that will not go your way, and you have to amend it. Now, that doesn't mean don't get upset at your lawyer if you get a bad ruling. It happens. Explain what are the consequences, what is the significance of this ruling, and how it can be fixed. And the attorney will explain that to you. And the reality is when you go in front of a judge, it's a 50-50 chance it can go either way. And if you've done this long enough, there are motions that you may think you may not win, and you do your best argument, and sometimes you win them. And sometimes there are motions that you believe that you have everything in place, every single case law, everything, you have everything down to every single detail, and it doesn't go your way. Judges are humans too. It's human beings. So they sometimes may not get it right, might not understand it. It happens. So we are prepared for that, and that's what we have co-reporters at those hearings in order to preserve the record in the event that we have to do an appeal. But that's just an example of a ruling that cannot go your way. Another example of a ruling that sometimes can be a negative ruling is, for example, somebody wants to do what's called a third-party subpoena to a witness that is relayed that have some information about the case. And usually it's very common to, when dealing with financial records, subpoena banks and financial institutions, credit card companies, in order to get documents from the bank if it deals with some type of financial transactions. It is very common to object to those types of subpoenas on the basis that they might be overly broad. There's the issue of confidentiality as well, the confidential records. So if somebody objects to a subpoena, then we have to go in front of the judge. The judge may decide, yes, there is there's a likely that we need this information. And again, the rules on evidence are very liberal to the extent that if the information that you're trying to obtain, it is likely to lead to the discovery of admissible evidence, it is likely that they will allow you to issue that subpoena. In some cases, the judge may narrow the subpoena to be more focused to what you need for the case and not make it so overly broad. So there are a lot of different reasons why to object, but just as an example of, the judge may say, you know what, I'm going to allow it, it's relevant. And then there are things that we can do to protect information, like a confidentiality order, for example, that we can do that, and we can request that as well. The important is to having a process that you can preserve the record in the event that you have to, file an appeal when the case is over. Another example of when things can go wrong in your case, or things that can affect your case, is newly discovered evidence. Perhaps there's a text message that the opposing side has that has you making an admission that it can be construed negative in your case. And that information was not available to your attorney in advance, and it shows up in a deposition. And it happens very often and you're in a position for our client, it is very likely that we get to know new things about the case that we were not aware of before. And if you have heard this podcast before, and hopefully you have, the I talk about telling your attorney the good and bad and the ugly, telling your attorney everything about what's happening in the case, and not withholding information from your attorney. Because if there's a text message out there that is not favorable to you, it is likely the other side has that information. And the other side is going to give it to the attorney, say, here it is, here's the admission, here's what he told me or she told me. And it's going to be utilized on a cross-examination. It's going to be utilized in your deposition. So I rather, from my perspective as a litigation attorney, I'd rather have all the bad news right up front. Just give me everything, okay? Even if you feel that it's not that important to the case, and I get that all the time, I forgot to tell you, so I don't think that was important. Let us make that decision. Don't decide what information is important or not important to the case. Every single fact is important because we're trying to put a puzzle together. We're trying to, especially in business litigation, it's a story. It is, stems for the most part from a contract dispute. A dispute that, two or three people agree to do something or enter into this partnership or enter into the business venture. And along the way, something went wrong. Either there was a misunderstanding about what the agreement was going to be, whether one of the parties did not fulfill the obligation within the contract, or one of the parties decided not to do it anyway, decided to, cancel the contract or repudiate the contract and did not allow the other party to continue. There are just a lot of different reasons why disputes occur in a contract, in a contract base, in a contract dispute. So by not giving us that information and having that new evidence be available or be presented for the very first time in an email or a text, and have your attorney see it for the first time in a deposition, it just, it puts a lot of pressure on that attorney because he has to figure out a way to handle that piece of information. And during the deposition, he cannot ask you questions. He cannot coach you and basically, or say, have a meeting with you. I want to talk to you about this while your deposition is taking place. You're on your own until the end of the deposition. So that is important for your attorney to know everything about this case, everything that you have, every text message, every email, even if you believe that it's not that important, because it could be important. It could be that thread, that dot that is missing. It can provide context to the communication or that you had with that other person. So that is important, and I cannot emphasize that enough, that information is essential to have. And again, the good, the bad, and the ugly, tell your lawyer, don't hold anything back. It's extremely important. Another thing that I get questions on is that, when the other side is suing, you file a motion to dismiss, okay, and they agree or the judge rules against them, say, okay, we're going to dismiss the complaint, and but they file another amended complaint, which in essence starts a lawsuit all over again to a degree, because you can only do that so many times before the court says, I'm not letting you amend anymore. But the rules of amendments in Florida is that it's liberally construed, and you can amend as justice shall require. So an example of how to amend the complaint, or why would you want to amend the complaint, is that sometimes you take depositions, testimony, or you get some interrogatories or some new documents that come in, and new evidence were shed to light that you say, okay, I didn't have this piece of information, but now that I have it, I want to add it to the complaint to make the complaint more complete. So newly discovered evidence is a valid reason why to amend the complaints, and clients get frustrated sometimes. Oh, they got to file it again. So what happened to the last one? And well, it got amended, and they have the right to do that, just like you have the right to amend your affirmative defenses as well, or if you have a counterclaim. So both sides have the right to amend their lawsuits, but it is frustrating because you spend this amount of money to defend the initial lawsuit, it got dismissed, then they file another one, and then you got to basically either you're going to file a dismissal, a motion to dismiss of that particular amended counter lawsuit, or you're going to go ahead and answer it. And there are two different decisions to be made, but that's something that has to be decided on a case-by-case basis, depending on the amendment itself. Sometimes you file another motion to dismiss because the amendment was not properly done or they still have defects. And at that point, you can begin to ask for dismissal with prejudice. But that's later down the road. From your perspective as the client, it's just basically looking at the starting of the lawsuit kind of again. So it is frustrating when that happens, but it is something to be expected that the pleadings will be amended along the way. It's not a bad ruling, but it is frustrating because you kind of basically have to start from the very beginning or somewhere in the beginning of the case. You still have not taken a discovery, you have not taken any depositions, you have, sometimes it's frustrating. And sometimes you make a calculation that to advance the case, you decide, you know what, I want to advance it, and I just want to go ahead and answer it, get, affirmative defenses filed, and maybe move for a motion for summary judgment and try to end the case. And the motion for summary judgment is a different topic that I'll talk about at some point, but it's a way that you can actually tell the court there are really no issues of fact anymore. These are the facts that have been admitted, already established through testimony, and there's really no dispute as to the facts. So we need the court to rule on this based on law. So if it's so that's a way to a degree, short circuit the case, and it puts a lot of pressure on the other side to overcome the burden of a motion for summary judgment. But we'll talk about that another time. So it is important that when you get a ruling that is not in your favor, not to panic. There will be a number of them along the way. There could be on discovery objections, for example. You get an interrogatory, and you don't want to provide, you believe the information they're asking you, it is irrelevant, not likely to lead to discover admissible evidence, is completely outside of the scope of the pleadings. You file that objection, but you have a hearing, and the judge rules no, you have to provide the answer. The same thing with documents. So every time that there's a dispute as to documents, as to subpoenas, as to evidence that have to be provided, interrogatories, questions at the deposition that you might not want to answer, or the attorney instructs you not to answer, all those items will go back to the judge for the judge to rule. And sometimes it's a uniform motion calendar hearing, a short matters hearing of 5 minutes. Sometimes it's in a special set hearing that could be like 50 minutes or 30 minutes, so you can get all those hearings at once, all those matters be ruled upon at once. But you have to understand that throughout the course of the case, there are going to be a number of hearings that you will have, that your attorney will be appearing on, and you're going to have some rulings to go your way. Doesn't mean that you won the case. And there's some rulings that will go against you, against your position, but that does not mean that you lost the case. It only means that that particular item, the court ruled that way. And we prepare an agreed order, and they'll send it to the court. It will proceed with the case according to what the court instructed us to do. And the frustrating part to you as the client is that you feel that you do not have control of the litigation, and to a degree you don't. We have our deadlines, we have our procedures to follow. In terms from the client perspective regarding what we have to do with the court and the court's rulings and the court's motions, the client has very little control. We'll update you on what's happening, but the reality is you don't get to make the decisions. The judge does, and it is frustrating to you. We understand that. The key here is try to avoid situations where you have to go in front of the court all the time. to be practical about it and be strategic about it. Sometimes there's reasons why I'm going in front of the court. Sometimes they're not. And I'll give you an example. There might be some type of admission or some type of information that it is favorable to your case, but the opposing counsel does not want to, agree to provide those documents or agree to answer certain interrogatories. So in that case, you want to go in front of the judge because you want to explain to the judge your story. The judges have about 3,000 cases in the average. So the more they remember your story at the end of the case, the better. So as an example, why you want to go there. In some cases, if you feel that there's a likelihood that the court is going to rule against you, and you have a good idea if you've done this for a long time, then the better approach would be to enter into an agreed order with opposing counsel and just get it resolved. So if they want better discovery for whatever reason, the client did not provide the complete set of documents that the client has, you say, you know what, we'll enter an agreed order, we'll do a diligent search and go ahead, and if there are additional documents, we'll provide them, but let's not go in front of the court for that. We can just agree among ourselves, we'll enter an order with the court, which is as good as going to the hearing. The court signs it, but you don't have to spend the time and the money spending an hour in front of the computer waiting for your turn for 5 minutes. It's just more practical to do that, and it's a more professional approach, but also it saves you money. So the idea is to be cost effective, to be strategic, but also to be smart as to when and go in front of the court, when you do not want to go in front of the court. So you have to be proactive, you have to be flexible. But the key here is that when you have a negative ruling, or a ruling that does not, a negative ruling that's not going in your favor, just ask your attorney, what is the consequence of this ruling? How does this affect the case? What is the next step from here? How can we fix this? And your attorney will explain that to you. But if you have any takeaways from today's podcast, is that you will have negative rulings along the way. You will have either situations that, in your case, that things will go wrong, whether it will be newly discovered evidence that it was not available at the time, that it just came to light in a deposition. Maybe it's a witness that surfaced that we were not aware of that can testify against you. Whether, maybe an admission that you made, perhaps taken out of context, maybe some documents that a third party has that are not good for your case. There are just a number of potential reasons how your case can go wrong, but hopefully you're not going to have too many of those. I think that in litigation, there are many different defenses, and the idea is to understand what is the significance of that particular ruling and how to handle it. And also, there's always the opportunity that if a ruling is so significant to your case, you have the option to appeal that ruling to the District Court of Appeal. In Florida, you have various circuits, but that is always an option. And you can always ask the court to reconsider that particular ruling. In fact, in Florida, before you file notice of appeal, you have the obligation to ask the court to reconsider the ruling and ask for a rehearing. That's a requirement now before you send any type of pleading to the Court of Appeals, because they want the lower court to give them an opportunity to take a look at this one more time before it goes to the Court of Appeals. And if they decide, sometimes the judges say, you know what, yeah, you're right, this is something that I overlooked, I want to reconsider it, and perhaps the matter gets resolved at that point. Or the judge will say, no, I'm stand by my ruling, and then they sign off, and then you have the right at the end of the case, depending on the type of order that it is, to take that to the Court of Appeals. So there are different options available for attorneys, but the key here is that not to panic, and stay calm and just listen to your attorney to explain to you the significance of that particular ruling. And when you understand the significance, you realize It's not a big deal. It's just part of the process. It's an adversarial system, and you're not going to have a case where every single motion that you have is going to go in your favor. It's never happened to me. It's not going to happen. It's something that is part of the process. But the idea is, what is the significance? And even if you lose your case, okay, you still have the option to negotiate. You still have the option to go up to the Court of Appeals as well. So there are a lot of options available, even if things do not go your way in a case. And I want to at least leave you with that. The key here is not to panic. Talk to your lawyer. It's important to discuss this matters with your attorney and not to panic, and then take a deep breath. It's going to happen. It's part of the process. And that's nothing to do with the attorney's skills. Could have something with the judges, judges have biases in reference to their background, their experiences, what the experience they bring to the case, and how they look at cases as well. They're human beings. And I said bias is not in a negative way, meaning that they have experience. They have some experience that they bring to the bench. And sometimes they might know a lot about a subject matter because they basically practice in that area and prior becoming judges. Or perhaps they're just learning the matter for the first time. And sometimes we have to educate the judge about a particular area of law. It happens. They don't know everything. They're just learning as much as we are, but they have experience as well. And they're doing the best they can in difficult circumstances. So I want to leave you with that for today. Remember, if you want to reach me, my email is richsierra.com. My website is floridasmallbusinesslegalcenter.com. If you want to take a look at my book, it's Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available at Amazon, Barnes & Noble. You can ask for any local bookstores. Remember that if you like the podcast, please follow us and subscribe. I appreciate a good review. And also, if you're watching this in YouTube, my YouTube channel is youtube.com/RichardSierra. You can subscribe. So our podcast that you're listening today also are available on our YouTube channel. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.